Any commentaries made by today's esteemed speakers are not official statements from Ballet Philippines. Good afternoon to our special guests. Welcome to Ballet Philippines' 53rd season. This masterclass is special because it was designed to empower and engage not just the dance world, but the entire creative community. So, thank you so much, everybody, for joining us this afternoon. We also look beyond our sphere of creative circles and open this masterclass to companies and organizations that often collaborate with creatives. To give her welcome remarks and talk in detail about this masterclass on creators, copyright, and intellectual property is Ballet Philippines President Kathleen Lichtenstein.
Thank you, Rossi, and welcome to all of you joining Ballet Philippines' 53rd season Masterclass on Intellectual Property. While Ballet Philippines' mission is to entertain, educate, inspire, and aspire, our vision to empower the creative industry has never been more relevant as we advance into the digital world post COVID. It is our aim that today's forum may help artists and audiences alike form informed decisions or opinions on their careers based on facts and the law rather than manipulated facts, half truths, and biased opinions. To celebrate our first live performance after 2 years under the COVID lockdown. We're giving each one of you a ticket to our gala, Echoes and Other Ballets on September 17 at 8 p.m. at the CCP Main Theater. Have a wonderful learning afternoon, everyone. Over to you, Rosie. Thank you.
Thank you so much, Ms. Maymay. Thank you for that wonderful and inspiring message. To moderate today's masterclass, a legal expert on corporate, commercial, and entertainment law is Attorney Lorna Pataho Kapunan.
Hello, I'd just like to say hello to all the participants in your masterclass for creators. It's really an amazing sector. In fact, in the DTI, that is one sector that we have been trying to promote this time, and we're trying to have the Senate, Congress pass a law that will promote the creative industries. That is really a high potential and a very fast-growing industry even without government support. So what more with government support? And I just want to invite everyone to, hopefully you tie up with DTI. There is also the IPO field that will take care of all copyrights and intellectual property protection para sa inyo pong mga creations. But certainly all these creative industries really are the future, the now and the future. So more power to you all and enjoy your masterclass. Maraming salamat po.
Hello, I'm Mylena Biva. I'm the president of Felta Multimedia Incorporated, as well as the chairperson of the Women's Business Council Philippines and the World Robot Olympiad Ambassador. To all our participants in this masterclass on creativity, I assure you that innovation, particularly for those in the techie field, is the field of the future. I would like to also announce that the robotics team, who I lead, is already patenting our inventions from the Department of Science and Technology, Technology Applications and Promotions Institute. So, ang galing, right? And for those who like Minecraft, we are also doing Minecraft education using Code Builder, where we build fields and worlds where we're doing the SDG and solutions for these worlds. And we also were the winners of the Global Minecraft Challenge by Microsoft. Mabuhay kayong lahat and God bless us all. Stay creative.
Hi, I'm Ida Chongson. I'm the chairperson of ProLife UKPH. I'm also part of the Bangko Sentral Open Finance Committee and a trustee of Women Biz as well as FinTech Alliance PH. With the advent of technology, yes, it has helped a lot of the businesses. Unfortunately, there's a dark side to it, as today it's easier to poach ideas. People can just copy and take it as their own. What's your protection? I think this masterclass is a great avenue for you to learn and better understand the importance of copyright and having intellectual property ownership. They say prevention is better than cure. If your ideas may have been copied, it's harder and expensive to legally chase than protecting yourself now. In fact, if I may say so, in the last COVID, the complaints has gone up compared to the 2013 to 2019, 2020, 21. There's been many, many poaching of ideas. So it's about time to know how to protect yourself. So welcome to the masterclass of creators, copyright, and IP. I'm sure you're going to have a fabulous time learning how to protect yourself. Thank you.
So I'd like to say good afternoon to everybody. I hope you can hear me. Before we start this presentation, I'd like to say hello to everybody and thank you to Ballet Philippines and to its President Maymay Lichtenstein Lior for thinking of this masterclass session for our artists, our creators, and for business in general. You have just heard welcome messages from three very important people to show you how important really intellectual property is to you as creator and artists, to the community and the businesses and professions you belong to, and to the nation in general. You have heard messages from the Honorable Ramon M. Lopez, who has had a solid career in government. He was the former Secretary of Trade and Industry and 22 years of experience in the business sector. He has been Executive Director of Go Negosyo for the past 11 years. You also heard earlier Mylene Abiva, my chairman of Women's Business Council, also president of Felta Multimedia Inc., and the World Robot Olympiad ambassador. And lastly, you heard a welcome message from Idia Tiongson. She is chair of ProLife UK Philippines and also a member of the Bangko Sentral Open Finance Committee, likewise a co-trustee of the Women's Business Council and a trustee of FinTech Alliance Philippines. The reason I felt that these messages were important is so that you realize that intellectual property is not only about the academe. It is not only a subject in school. It is not only something that you are forced to learn about. It does have importance in terms of what your own rights are as artist and creator, what your intellectual property assets are, and how important they are to your business and to your profession, and how, as Honorable Ramon H. Lopez, former DTI Secretary, has said, how intellectual property is very important in terms of nation building. So this afternoon, we are joined by none other than a legal expert. I will introduce him properly next time after this, but let me just give a few introductory words. You know that every business will have some form of intellectual property, not just those that deal with technology. To appreciate the importance of this intellectual property, it is necessary to understand the nature of different intellectual property rights, what they protect, and how these rights can be obtained, and how they must best be commercialized. So, generally speaking, intellectual property can be seen as a bundle of property rights that protect creations of the mind. These rights can be crucial for you, your business, not only not only can they be used to protect your own creations, but they also provide useful business tools that can be exploited commercially. Our focus, ladies, gentlemen, friends, and all of you who are curious about ano ba tong intellectual property na to. Okay. This webinar will focus, or this masterclass will focus on copyrights. Copyright exists to protect the expression of ideas and to protect original written works, including computer codes, as well as works of art, including drawings, sculptures, and photographs. Intellectual property rights can be put to use in a number of ways. On one hand, IP can be seen as a negative right. A negative right. What does it mean? That is, it can merely be used to prevent others from copying your written material or producing products that infringe upon your creation, your patents, or your designs. From this, you obtain a competitive edge. On the other hand, and more important, intellectual property can be used in a positive sense. Since intellectual property is a property right, it can be like other properties, mga bags, shoes, kotse dyan, land. It can be bought, and it can be sold. It can be licensed so that others can use your brand names, your creations, or make products that fall within your patent, from which you will receive a royalty payment. Intellectual property can be used to give you the upper hand in negotiations. For you who are in the corporate world, intellectual property is also a corporate asset, and you can use it to increase the valuation of your business. And it can be exchanged for mutual benefit. Furthermore, and because we now are a global world, intellectual property rights can be obtained and protected globally, unleashing your business potential to the global market. It must be also borne in mind. Tandaan rin natin that not only is your intellectual property right important, we must likewise protect the intellectual property rights of others. You will need to be aware of your competitors' rights so that they are not infringed, which could put you and your businesses at risks. So important to you as artists, creators, and important to business and professions is intellectual property, which must have a social function in terms of nation building. Okay, with that, can I now show to you a short video to give you an overview of what intellectual property rights are all about. Intellectual property drives progress. It refers to knowledge creation, such as industrial innovations, such as new product inventions, such as science and technology advances, such as research papers, those of you in the academia. It also relates to designs, creative products in the form of books, paintings, songs, and the like. Intellectual property can be bought, sold, licensed, or exchanged. Legal rights are conferred on your intellectual property, and they are called intellectual property rights. The owner of an intellectual property right can prevent unauthorized use of the intellectual property and can take legal action to protect such rights in case someone else uses it without permission. Let's get together to protect intellectual property. And thank you to the Confederation of the Indian Industry for allowing us to share this content. So back to me. And I'd like to introduce our guest expert lecturer for this masterclass. Attorney Rico Domingo is a Filipino lawyer, also admitted to the New York Bar and the U.S. Federal District Courts. He is the immediate president of the Philippine Bar Association, which is the oldest voluntary national organization of lawyers in the Philippines. I call him Rico. So Rico is also the chairman and lead convener of the newly incorporated Movement Against Disinformation, MAD, which core advocacy is to effectively address the proliferation in the mass media of disinformation, misinformation, and fake news through the internet and analogous social media platforms. Attorney Rico is an academician. He taught at the Konrad Adenauer Asian Center for Journalism, the Communications Department of the Ateneo de Manila, and has been teaching many subjects in premier law schools, including my own school, the University of the Philippines. This includes subjects like constitutional law, media law, ethics, remedial law, and very important, intellectual property law. Rico is likewise a faculty member of the New York State Bar Association's continuing legal education. He is a certified arbitrator of the International Chamber of Commerce. Enrico held a brief stint in government post-EDSA as the first chairman of the Videogram Regulatory Board, which is now the Optical Media Board, and was general counsel of the Film Board. He later joined the Motion Picture Export Association of America and is its Asia Pacific Regional Counsel. In October 1992, Rico established his own multi-jurisdictional law practice with the firm that bears his name. He concurrently founded a business and competitive intelligence consultancy firm which provides, among others, brand or intellectual property rights protection, risk management services, and litigation support. A recognized law lecturer and panelist, Rico speaks in various domestic and international fora on international business transactions, cross-border litigation, arbitration, and intellectual property rights enforcement and protection. Scholar ng bayan si Rico. From elementary to high school, he was at the University of the Philippines, where he also finished his College of Law. His master's degree was obtained at the Indiana University Moore School of Law, Bloomington, Indiana, and postgraduate studies at Harvard University and Cambridge University. He is also my fellow trustee at the Intellectual Property Association of the Philippines. Please welcome classmates in this masterclass, Attorney Rico V. Domingo, our masterclass lecturer for this afternoon, who shall walk you through your intellectual property, your rights, how to protect them, especially on copyrights. It is indeed important on knowing how to protect and assert your legal and property rights. Mahaba pa to, pero Rico, thank you again on behalf of the organizers of this masterclass. Thank you for accepting this invitation. To you, Rico.
Yeah, thank you. Thank you, Lawrence. Actually, thank you very much for your kind words, Lawrence. Actually, if you may call the expert on intellectual property, it should be Attorney Lorna. No? We've been together for quite some time. We are in the Intellectual Property Association of the Philippines. He was our past president. And of course, you know that she had been in this practice for quite some time. But I'm a little older than Lawrence, but we were graduated from the same law school. Anyway, thank you very much again, President Kathleen, and the other members of the Ballet Philippines for inviting me over to this lecture series, which should be under the aegis of the 53rd season of the Ballet Philippines. No? So without much ado, I would like to give you already my presentation and walk you through an outline. And allow me first at this juncture to wear my professorial hat and present to you what I'm going to discuss to you this afternoon. I will give you an introduction very quickly on the primary objective of the intellectual property law, the constitutional provisions, the international conventions, as well as the statutes on intellectual property, categories of application of intellectual property, types of intellectual property law, and of course, very important for all of us would be, I will show you why there are misconceptions and confusions on intellectual property rights. Then I will zero in, which is the meat of my lecture, on copyright law, which is probably the most important intellectual property law from the standpoint of the knowledge creation industry, as well as the creative products of the creative workers. Okay, I will talk about what is copyright, what works may be copyrighted, and how is copyrighted created, who owns a copyright, can copyright be divided or transferred, how long does copyright protection last, what happens if copyright is infringed or unauthorizedly used, may a copyright work be legally used without an owner's permission, and we're talking about the fair use doctrine, and how to protect your copyright in art, sculpture, literature, music, songs, choreography, crafts, poetry, flowcharts, software, photographic movies, CD-ROMs, video games, videos, graphics, allied copyrighted works. Then the final portion of my lecture would be on remedies under copyright law. At this stage, I would like to tell you what I've been telling my audience since the time that I started practicing intellectual property. It's about 45 years ago, and that aged me. If you do not, or if you are unable to protect what you own, then you own nothing. Remember that. If you're not able to protect what you own, then you own nothing, nil. The primary objective of intellectual property law is not to reward the labor of authors that was articulated by the earlier introductory speakers, but to promote the progress of science and useful arts. And to this end, intellectual property law assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed by the work. This is what we call in intellectual property ideology as the idea-expression dichotomy. and it applies to all works of authorship. Although protection, as correctly said by Attorney Lorna, intellectual property is long-lived, it only applies to the literal expression, not to the ideas or concepts underlying the expression. We have several constitutional provisions of this. I will not belabor you on this, but we have Article 12, Section 6, Article 12, Section 14, Article 19 or 59, Section 10 to 18. And these are all enshrined in our Constitution, and these are all to promote science, art, and culture provisions, which are translated in several conventions, international conventions. We have the Berne Convention for the Protection of Literary and Artistic Works, as revised in the Brussels Act, then ratified by our Senate in June 1948. Then we have also the Paris Convention for the Protection of Industrial Property Rights, or Paris Convention, which was ratified by our Philippine Senate on May 10, 1965. Then we have the International Convention for the Protection of Performers, Producers, and Phonogram and Broadcasting Organizations, which is also in brevity called Rome Convention, which was adopted in October 1961 and was enforced in the Philippines starting on 25 September 1984. Then we have, of course, the WIPO, the World International Property Organization, and this convention entered into force and effect in the Philippines on July 14, 1980. As correctly said again earlier, we are actually part of these conventions. We are country signatories to these conventions, and they are effective within our jurisdiction as well. Another treaty that we had access to would be the international recognition of the deposit of microorganism for the purposes of patent procedure. We will learn that later on. Which took into effect in the Philippines on 21 October 1981. We have the Budapest Treaty, the international recognition of deposit of microorganism, which took effect in October 1981. And of course, the latest basic and the most important international convention on intellectual property would be the Agreement on Trade-Related Aspects of Intellectual Property, which we call for short TRIPS, which was challenged by some parties in the Supreme Court, but it was ruled to be constitutional in Tañada versus Angara. It was ratified by the Philippine Senate on December 14, 1994, and signed, and the date, we, of course, we mourn the passing of President Ramos. It was ratified and deposited as an instrument of ratification on 16 December 1994. There's a Doha Declaration of Public Health, and we have the Patent Cooperation Treaty, which entered into force in August 2001. And we have, of course, the Madrid Protocol, which is an international registration treaty which our association challenged as not very constitutional, but nonetheless, it was upheld. The constitutionality of Madrid Protocol was upheld in July 2016. Then we have the Philippine Statutes on Intellectual Property. We have the Republic Act number 1287, which grants privileges to any person who discovers or invents a new process. We have also Presidential Decree number 812, which took effect October 1975, which is called Decree on Legal and Cultural Deposit, to be able to store and preserve our legal and cultural deposits and materials. Another Republic Act would be 7459 on Inventors and Invention Incentives Act. This will provide incentives to Filipino inventors and expanding the functions of the Technology Application and Promotions Institute. It is now in force, and we will discuss that later on if necessary. Republic Act number 8047 is an act for the development of book publishing industry. Since this is a multi-sectoral lecture, so I'd like to also tell the book industry that they are also covered by this Republic Act 8047, which took effect June 1995. And finally, we have the Republic Act 8293, amended by Republic Act 100372, which we call famously as Intellectual Property Code. And most of my discussion right now will be based on Intellectual Property Code. What are the categories of intellectual property law? It encompasses all the statutes, government regulations, and court decisions that determine who own intellectual property and what rights go along with that ownership. It specifies the conditions under which intellectual property rights may be transferred for specific purposes, how to settle contract disputes that arise from marketing intellectual property, which was partly discussed by Attorney Lawrence, and how to take advantage of substantive and procedural laws that establish for or enhance protection of intellectual property rights. It can be categorized into trade law, or trademark law rather, unfair competition, patent law, trade secret law, and of course, the copyright law. All of them are incorporated into the Intellectual Property Code of the Philippines as amended. Now, what would be the misconceptions or confusions in intellectual property rights? They say you do not copyright a brand name, nor does the government give you a patent on a trademark. And in this jurisdiction, it's not essential to the protection of brand to have it registered rather. In fact, the venerable intellectual property rights expert Cooley on Torts in 1888 made reference to quote unquote patenting a trademark, which is actually an oxymoron or something that is a misconception whatsoever. And this confusion is engendered by the fact that most of these intellectual property rights, patents, trademark, and the others are actually being regulated by one office as actually modeled by the US Patent and Trademark Office as well. That's why we had the Philippine Patent Office, later on the Bureau of Patents and Trademarks and Trade Transfer Technology, and now the Intellectual Property Office supervising or regulating or managing intellectual property rights. Now, in respect of copyright, the National Library would have concurrent jurisdiction over materials like literary works with the Intellectual Property Rights Division of that department. Now, most of you are familiar with Peanuts, right? And in this particular comic strip, Linus and Lucy are debating, and Linus was complaining, it's raining, and every time I say rain, rain, go away, come again some other day, then the rain would stop. Then frightened, Linus asked Lucy, if do I have some prophetic skills that when I say rain, rain, go away, come again another day, the rain stops? I might be stoned. Then he said, do I have to protect myself? I wonder if I can be patented. Now, the question is, can a human being be patented? So that's one of the misconceptions. Trademark protects the distinctive, unique, creative, or well-known through use, names, designs, logos, slogans, symbols, colors, packaging, containers, and other devices that are used by businesses to identify the source of their goods and services and distinguish them in the marketplace. This is trademark, okay? We're talking about trademark. These are some of the famous trademarks that you are encountering almost every day. And most of you probably are wearing them or using them. These are the top 100 trademarks all over the world. What about unfair competition? You've heard about unfair competition. It's just like trademark, probably. But because of its usage in several jurisdictions and in disputes between trademark owners, it has become or emerged as a sui generis, as a class of its own, and that's why it was incorporated in the Intellectual Property Code as an independent body of area of law. They call it unfair competition, and that usually is a considered separate branch of intellectual property law because it targets general business practices rather than the intellectual property as such. But because of the use of misleading names and marks to improperly lure customers away from another business is also very much what trademark law is concerned with. Then trademark and unfair competition laws often overlap. That's why the legislators decided to put or incorporate them into our intellectual property law. What about patent? Linus was asking whether he should be patented. Well, patent law gives the inventor of a new and non-obvious invention the right to exclusive use of that invention for a limited term. As correctly said by Attorney Lawrence, it is actually a monopoly within a certain period. And if you are an owner or registrant of utility patent, you have 20 years of monopoly from the filing date of the application. And you are an owner of the industrial design or patent, then you have 5 years from filing date of the application, renewable for not more than 2 consecutive periods of 5 years, or a total of 15 years. And of course, we have the patent on plant. Section 25 governs that. I will not belabor you with the provisions, but nonetheless, that is patent law for you. Now, what is this animal called trade secret? People who cannot cover their inventions with patent law because they are not patentable, as we call it in IP practice, then they resort to trade secret. And the trade secret would consist of formula, pattern, physical device, idea, process, compilation of information, and other information that provides the owner of the information with a competitive advantage in the marketplace and is treated in a way that can reasonably be expected to prevent the public and competitors from learning about it, absent improper acquisition or theft. That's trade secret for you. Now, do we have a trade secret law here in the country, in our country? No. We have a trade secret law in other jurisdictions, particularly in the United States, and almost all the states in the United States are subscribers to patent law, or I'm sorry, to trade secret law. So it gives the owner of the trade secret law or the trade secret a competitive advantage in business because they have the trade secret. But of course, when the trade secret becomes of public knowledge, then it ceases to be a trade secret, and therefore it can be appropriated as a public domain. As I mentioned, there's no trade secret law in the Philippines, but I think the legislative mill would like to introduce something along that line as a model to or for our United States Uniform Trade Secret Protection Act in the federal jurisdiction as well. What are the examples of trade secrets? Here they are. Even orders or processes can be a trade secret. So if you have a peculiar order, you can have it. That's a trade secret. And what is the most famous trade secret? I usually have this as a part of my quiz in my trademark law class. Coca-Cola. Discovered in 1886 in Atlanta, Georgia, by John Pemberton, but he was a lousy marketer, so he licensed it to us as a candler. Initially, it was with cocaine, and later on, because of the food Drug Administration, they removed the cocaine content and is now without any such toxic substance. It is estimated the value of 2021 US 56 million, but I think that's understated nonetheless. Probably the most known, as I mentioned earlier, among the intellectual property law or laws would be the copyright. And copyright automatically applies to all types of regional expression, including art, sculpture, literature, music, songs, choreography, crafts, poetry, flowcharts, software, photography, movies, CD-ROMs, video games, videos, and graphic designs, and so on and so forth, and allied creative works. Copyright law protects all types of original. The operative word is original creative expression, such as that produced by authors, composers, artists, designers, programmers, and web page designers. Does not protect the ideas and concepts underlying an expressive work. You may have a million ideas, you may have a million concepts, but if they're not translated into expressive work in a medium, a physical medium, then it is not copyrightable. It only protects the literal form the expressive work takes. Now, what are the creative works protected by the copyright law? Of course, Section 172 of the Intellectual Property Code provides what works can be copyrighted. Literary, artistic works, original. And what is important is to remember that they are protected from the moment of their creation, and we do not need to have them registered to be able to enforce the copyright in that particular subject. Registration is simply for evidentiary purposes when you go to court to present your evidence, but you do not need to register them to protect or to enforce them as a copyright. And what are they? Books, pamphlets, articles, and other writings, periodicals and newspapers, lectures, sermons, addresses, dissertations for oral delivery, and or they may be in writing or not reduced in writing or other material form. Letters, you have a lot of letters, you can have them copyrighted. Dramatic or dramatico-musical compositions, choreographic works, or entertainment in dance shows, which is very important in the Ballet Philippines context. Musical compositions with or without words for the musicians. Works of drawing, painting, architecture, sculpture, engraving, lithography, or other works of art, models or designs for work of art. Original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design in a patent law context, or other works of applied art. We have illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. Drawings or plastic works or scientific or technical character. Photographic works, including works produced by the process analogous to photography, lantern or slides. Audio-visual works and cinematographic works and works produced by a process analogous to cinematography or any process for making audio-visual recordings. Pictorial illustrations and advertisements are copyrightable, provided they are original. Computer programs, of course, you know, are copyrightable. And finally, as a catch-all provision, other literary, scholarly, scientific, and artistic works. Let's go one by one and find out if we have some graphics on this. books, pamphlets, articles, and other writings. Periodicals and newspapers. Lectures, sermons, addresses, dissertations for academicians. Letters. All of these are copyrightable materials and works. Dramatic or dramatico-musical compositions, choreographic works, or entertainment in dance shows. We have that national artist, Ryan Peabyon. Musical compositions with or without words. Works of drawing, painting, architecture, sculpture, engraving, lithography or other work of art, models or designs for works of art. I can see a more solo painting there. Original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design or other works of applied art. Illustrations, maps, plans, sketches, charts, three-dimensional works relative to geography, topography, architecture, or science. There you are, the West Philippine Sea. Drawings or plastic works of a scientific or technical character, they're all copyrightable. Photographic works, including works produced by process analogous to photography or lantern slides. Audiovisual works, cinematographic works, and works produced by a process analogous to cinematography or any process of making audio, videos, recordings. Pictorial illustrations and advertising or advertising materials, advertisements. Computer programs. And other literary, scholarly, scientific, and artistic works. Now, why am I showing this to you because I want to put a face on what we can protect by way of copyright law. And how is it created? How is copyright created? It is an original intellectual creation. Literary artistic works are original intellectual creations in the literary and artistic domain, protected from the moment of creation. As I mentioned, you don't have to register them to be protected. It can be protected, or they can be protected from the moment of creation. And no protection shall extend under the law to any idea, procedure, system, method, or operation, concept, principle, discovery, or mere data as such, even if they are expressed, explained, illustrated, or embodied in work. News of a day and other miscellaneous facts having the character of mere items of press information or any official text of legislative, administrative, or legal nature, as well as any official translation thereof. You cannot protect them. They have to be expressed in literal form, in concrete physical form. In intellectual property law, we have what we call derivative works, which would have the same force as in economic works, no? As in copyright. And derivative works shall also be protected by copyright as new works. And these are dramatizations, translations, adaptations, abridgments, arrangements, and other alterations of literary or artistic works. It may include collections of literary, scholarly, or artistic works, and compilations of data and other materials which are original by reason of the selection or coordination or arrangement of their contents. The operative word again is original. It should be original. Nobody had acquired that before or written that before. In addition to the right to publish granted by the author, his heirs or assigns, the publisher shall have a copyright consisting merely of the right to reproduction of the typographical arrangement of the published edition of the work, and that would be given to the publisher. Now, we have a bundle of rights, as Attorney Lawrence said. We have a bundle of rights. No? One of them is the economic rights. And it shall consist of the exclusive right to carry out, authorize, or prevent the following acts: reproduction of the work or substantial portion of the work, dramatization, translation, adaptation, abridgment, arrangement, or other transformative work, and the right to first publicly distribute the original and each copy of the work by sale or other forms of transfer of ownership. You can also rent it out. The right to rent the original or copy of an audio, visual, or cinematographic work, a work embodied in sound recording, a computer program, a compilation of data, and other materials or musical work in graphic form, irrespective of the ownership of the original or the copy, which is the subject of the rental. That would be an independently protectable right as an economic right. And of course, the right to publicly display the original or a copy of the work. Very important to our knowledge creation, particularly our friends in the Valley Philippines, would be public performance of the work. That is an economic right. And other excuse me, communication to the public of the work. That would constitute the economic rights of the copyright holder. What about the moral rights? The author of a work shall, independently of the economic rights that I have just enumerated, or the grant of assignment or license with respect to such right, have the right to, as moral rights, require the authorship of the works to be attributed to him. In particular, the right that his name, as far as practicable, be indicated in a prominent way on the copies and in connection with the public use of his work. You have to attribute that to the author of that particular work. The right to make any alterations of his work prior to or to withhold it from publication. That is his moral right. The right to object to any distortion, mutilation, or other modification of, or other derogatory action in relation to his work, which would be prejudicial to his honor or reputation. And another moral right would be the right to refrain the use of his name with respect to any work not of his own creation. I'm sorry, there's a typographical error. To restrain the use of his name with respect to any work not of his own creation or in a distorted version of his work. He has the right, as his moral right, to restrain the use of his name in that context. Now, who owns the copyright? So we talk about the rules of copyright ownership. Who owns the original literary and artistic work? Of course, the author of the works. In case that there'll be several joint authors, then in the absence of any agreement, then we go by the rules on co-ownership. If there are 3 authors, then perhaps they can agree on a one-third pro rata basis. Now, if the copyrighted work consists of several parts, then, and the author of that particular several parts can be recognized or identified, then those separate parts may be owned by those who have authored those parts. So it can be multiple authorships, provided that you can pinpoint who the author or authors of the parts involved are concerned. Now, copyrighted work created by an author during and in the course of employment. That's a very contentious issue nowadays. Many of the disputes amongst the parties would be involving that issue. Who owns the copyrighted work in the context of employment? The owner of the copyrighted work is the employee. If the creation of the object of copyright is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. Now, the owner would be in a different context if the employer, if the work is the result of the performance of his regularly assigned duties, unless there is an agreement expressed or implied to the contrary. So that would be the copyright ownership in the context of employment. What about commissioned work? Work commissioned by a person other than the employer of the author and who pays for it, and the work is made in pursuance of that commission, The person who so commissioned the work shall have ownership of the work, but the copyright thereto shall remain with the author or the creator unless there is an exception, unless there is a written stipulation or agreement to the contrary. Now, who owns the audiovisual work? The producer, the author of the scenario, the composer of the music, the film director, and the author of the work so adapted, if there is an adaptation of the work. And subject to the contrary or other stipulations among the creators, the producer shall exercise the copyright to an extent required for the exhibition of the work in any manner, except for the right to collect performing license for the performance of musical compositions with or without words which are incorporated into the work. Now, who owns the letters? The writer owns it, but subject to Article 723 of the Civil Code of the Philippines, which says letters and private communications in writing are owned by the person to whom they are addressed and delivered, but they cannot be published or disseminated without the consent of the writer or his heirs. However, the court may authorize their publication or dissemination if the public good or the interest of justice so requires. So there is a condition there. And the court is authorized to do that, to authorize the publication for the good of the country or the interest of justice as well. Supposing the work is done by an anonymous author or pseudonymous author, then the publisher shall be deemed to represent the authors of the articles and other writings published without the names of the authors under pseudonyms, unless the contrary appears or the pseudonyms or adopted name leaves no doubt as to the author's identity. Leaves no doubt as to the author's identity. There's a typographical error there. Or if the author of the anonymous work disclosed is identified or discloses his identity. Can copyrights be transferred or assigned? Yes. It can be assigned or transferred in whole or in part. It can be licensed as well. But we have to remember the principle that the property in the material object is separate and distinct from the copyright. No? You can own the property or the object, but you cannot own, or you are not the owner of the copyright. So you have to make a distinction on that. Okay. How long does copyright protection last? Writings, periodicals, books, plays, photos, illustrations, music, labels, work of art, etc. They are protected from the moment of creation, and the term of protection is generally lifetime of the author and for another 50 years after his death. Work of applied art, the acquisition right would be upon the making of the work, and 25 years from the date of making is the term of protection. Photographic works would be publication of the work, and 50 years from publication of the work. If unpublished, then 50 years from making of that published work. You can also legally use the copyrighted work using the fair use doctrine. And there are some provisions and some purposes or conditions where you can use the legally without legal work, without having to infringe. When you say infringe, you acquire the copyrighted work without any authority, and that is criminal in nature. But you can do that under these conditions, and with due respect to these factors as well: the purpose of the character of the use, the nature of the copyrighted work, the amount of substantiality involved, and the effect of and the use upon the potential market or value of the copyrighted work. These are some of the factors you will consider when you try to invoke the fair use doctrine, which means that you can legally use the copyrighted work without the permission of the authors of the copyrighted works. What happens when the copyright is infringed? You can sue the court. You can sue them to court. And you have several remedies. We have injunction, which means that we stop the copying. If we are prejudiced by the copying, you can also claim damages, actual, moral, and exemplary damages. You can also seize an impounding of the copyrighted works that supposed to have been infringed. And of course, you can destroy them if you can destroy also the infringing materials of products. And we have criminal penalties on that. These are there are criminal by way of imprisonment as well as fines and of course we have the affidavit evidence that shifts the burden so that it will be easier for you to prosecute a copyright infringement case under section 218. And that somehow concludes my lecture, and I'm sorry if I exceeded it by 5 minutes. Rory, I'm done. Thank you very much.
Thank you. Thank you so much for that, Attorney Rico. That was so interesting. That was such an enlightening discussion, Attorney Kapunan and Attorney Domingo. Thank you very much for that. Now we'd like to open the chat box for questions. We have a good number of organizations as well as creators in today's forum who I'm sure would have some questions. Kindly type up your questions in the chat box so we can read this out to our speakers. Okay, I was wondering if that was a question for you, Attorney Rico. Let me just ask the question again. Thank you very much for the insightful lecture. May I clarify what you mean by the copyright of the author is different from ownership of the work? Can you kindly give examples regarding this? This is from Katie. Thank you for the question, Katie.
For example, what I said about the commissioned work or work under employment, okay? It's possible that, for example, the creator of that copyrighted work is actually the copyright owner. But by way of stipulation or contract, the author or the owner of the copyright can actually assign it to his employer. That's another one particular example that I can think of. No? So in other words, what I'm simply saying is that it doesn't mean that if you transfer or license your copyright, it doesn't mean that the object of that copyright is also transferred as well or licensed. That is the principle that I'm trying to say.
Okay, we hope that that was a clear reply to the question. I'll go on to the next question. This is from one of our Ballet Philippines core dancers. For commissioned dance productions, I know there is some sort of joint ownership between the creator and the commissioning body. How can the creator, choreographer, protect the quality of work when the work is to be produced again, let's say 10 years after? Is it essential to inform the choreographer? And does it include royalties for showing the work again? I know this depends on what was agreed upon at the initial collaboration, but what is legally and morally right for the artist to do to protect his or her work?
You're addressing that to me, Rosie.
Yes,
Okay.
attorney.
What the choreographer in this particular example would do would be probably to make it clear in a contract or in the arrangement with the sponsor that she would like to be able to be advised ahead of time in a stipulated contract that any adaptation or anything that would relate to his copyrighted work, in this particular case choreography, would have to be with the permission of the author of that, the copyrighted work, the copyright owner. In other words, you have to stipulate that, make it very clear in the contract that that is the case, so that there'll be no dispute as to what would be the developments after the performance of that choreographic work already. So in other words, you don't have to rely on just simply verbal agreement. Put that in writing so that everything will be okay and everything will be above board.
Okay, thank you so much, Attorney Rico. I have another question from Ian. If I copyright something I created, but the organization that I worked for at the time paid me for it, who really owns it? Me or the organization?
Paid in what sense? Commissioned?
Uh, I'll read the question again.
Is it an employment situation or is it a
y-
commissioned situation?
I'm guessing that it's an employment situation because
Okay. Okay.
he said the organization that I worked for at the time paid me for it. So who really owns it, me or the organization?
If the one who paid him actually employed him, then even if he uses the materials and the facilities of the employment situation or employment uh, environment, then the copyright will be retained by the one who created the work in question. No? Unless, of
Okay.
course, there is a stipulation to the effect that the employer will be able to acquire that particular copyrighted work. Otherwise, the copyright will have to be retained by the employee. Now, in respect of if it's a commissioned situation, then the one who paid and paid the person who created the work, then that would be the work itself will be retained by the one who commissioned him, but the copyright of that particular work will be retained by the one who created the work.
Okay, I see. Attorney Lorna, I can see you. Would you have anything to add to that? Or we're good?
We're good with that. I think it should be emphasized that the relationship between the creator and, for instance, the employer is determined by contract. And that is why all creators and those of you who are listening to this must to avoid confusion in the future, must ascertain that there is a contract concerning your work. Because in the absence of a contract, as Attorney Rico has mentioned, the law will step in and you follow the law. If it is commissioned work, it belongs to whoever commissioned it. If it is done during your employment, it belongs to the employer unless there is a contract to the contrary. Rico, I also saw here question of a very good friend, Thelma San Juan. Hi, Thelma. And I'm also interested here because I also was a columnist of Business Mirror. She says for newspapers or magazines, the writer columnist owns the copyright. But if the work is written in the performance of duty, does the media employer own it? Thelma says that talking from her experience, for example, her newspaper, and we know, of course, her famous newspaper, lets the writers and photographers own the copyright. Rico, ikaw magsagot niyan.
Well, I think again, as you mentioned, you have to underlie that. You have to put that in a contract, no, between with the writer and the publisher, no? Because the writer will and the publisher will definitely have the copyright on any of the articles that would be published in his publication, no. But if the columnist would insist in a contract that he would preserve the copyright in that particular article or any written materials that he would be contributing to the publisher, then the contract will be prevailing. No? Yun ang mahirap eh. In fact, that was posed to me by the late Gary Olivard when he was asking me who has the copyright of that. And I said, why don't you just talk to the publisher that you want to retain the copyright of your articles? And I'm sure they would allow you to do that. No? So it will have to be embodied in a contract, on an arrangement, a written arrangement, so that there'll be no second guessing as to exactly what will be the arrangements between the publisher and the columnists of the articles.
Rico, iba ang, I think we should also emphasize that iba ang set of rights ng publisher. It's like the broadcaster.
Yeah.
The publisher has a different set of rights. Separate from the writer, columnist, like Thelma. No? She writes for famous publication. Iba yung rights ng publisher, which is the right to publish. No?
Yeah.
Attributing authorship to the individual columnist or writer, or if it's a photo, to the photographer.
Yeah.
Could you speak to that issue?
Yeah.
The rights of a broadcaster or a publisher.
You're correct. The publisher's bundle of rights would be different from that of the columnist. But again, the columnist would have the economic right as well as the derivative rights. No? So, in other words, the columnist can retain the economic rights as well to be attributed that particular article in his name and authorship. No? So that right cannot be diverse or divested from the columnist. So the publisher has to attribute the column to him or her, being the columnist. But again, as you mentioned, the publisher can retain the ownership of that particular work and have it published in his newspaper or whatever publication he has.
Is your chat open, Rico? There's a question here.
Yeah.
Joseph.
Netflix. Is that Netflix?
No, this before the next question. Joseph is a musical arranger.
Okay.
And he says, as a musical arranger, if I create an original passage, ad-lib in a song, can I claim ownership, copyright of that particular passage, making me a co-author of the song? Rico?
Well, depends upon, is that a major or substantial part of the song? Okay. If it's only a minuscule part of the song, you cannot really claim copyright in that. But if the portion of your contribution to the song is substantial, then perhaps you can claim authorship on that particular substantial portion. Depende yan. It becomes a factual issue. Kasi kung substantial naman, then you can claim copyright in those substantial portions. No?
Okay, another question here. If you don't mind, I'll be asking the questions. It's better to ask the questions than to answer them. So ako na lang yung mga taga-tango lang, ikaw na lang yung taga-sagot. Okay. Jimmy Bautista says, I thought copyright belongs to the employer. If the employee creates the work as part of their duties and there is an established employer-employee agreement, hindi ba klaro na it should belong to the employer? Rico?
Baka hindi. Because under Article 178.3, subparagraph B, if the work is the result of the performance of its regularly assigned duties, then it should be owned by the employer, meaning the copyright, unless there is an agreement expressed or implied to the contrary. Okay? So that would be the condition under which the employer will have the ownership of the copyright.
Okay. So I guess ang crucial na tatanungin dapat ni Jaime, no, is was the creation part of his duties? If it's part of his duties as an employee, then it belongs to the employer.
Correct. Part of his regular duties, and that he uses the time, facilities, and materials of the employer.
Okay.
Dapat yan, employer ang may-ari.
At kung hindi, sa employee yan, no?
Employee ang may authorship, ang may copyright ownership.
Okay, and follow-up to Ian's question, does payment or compensation make me totally ineligible to claim intellectual property rights for my creation? Kung binayaran na raw yung creation mo, can you still claim copyright?
Well, di ba meron tayo kanyang principle na sinabi na the object of the copyright will be different from the copyright, right? Ownership. So pag pinagbili mo object, it doesn't mean that kasama yung copyright doon unless you have stipulated that that is the case.
Okay. Yes, to me that's very clear. Okay, another question, and this relates to your Netflix question. There was an actual copyright case against Netflix regarding Sherlock Holmes. I love this Sherlock Holmes. Sherlock Holmes has been out of copyright and thus is in the public domain. Sherlock Holmes, however, is known to be cold and calculating. However, the newer Sherlock Holmes stories, which are still under copyright, portray him as warmer and emotional. Now, Netflix portrayed Sherlock Holmes as a warmer and caring person in the movie Enola Holmes. Netflix claims that feelings, personality traits, and emotions were not protectable. Okay, any comments, Rico?
Wala, hindi nga protectable yun. And if you depict Sherlock Holmes in a different light, then it depends upon the producer and the director if they want to do it that way. It is an adaptation, and perhaps it can have it can claim originality, and therefore it can have an authorship and copyrightable material of its own. So hindi naman dahil yung it will be a different impact on the audience share. No? It doesn't mean doesn't really matter as to who would be the author of that particular film. So the crucial thing there is that if there is a distortion of the original work on Sherlock Holmes, then perhaps the heirs of Sherlock Holmes, assuming they are still alive, can claim infringement of that particular work that attributed to Sherlock Holmes, which is, I assume, would be copyrightable as well.
Okay. Lisa De La Fuente says, and I think this is a question, the ownership rights of the commission ballet, because most of our audience here are ballet dancers and belong to Ballet Philippines and the CCP. The ownership rights of the commission ballet is different with the copyright of the choreographer. Did I get that right? Kasi
Again,
yung, I guess what the
again,
question
it depends upon the arrangement between the choreographer and the Ballet Philippines, no? Kaya nga, di ba, sabi natin, we are trying to underscore the fact that their arrangement has to be very, very ironclad as to exactly what would be the arrangement between the two of them. What are rights to be transferred and what are rights are to be retained. That's why, as you mentioned very, very judiciously, you said everything has to be in writing to protect your rights. Kaya dapat nun nakasulat, nakalagay yan sa kontrata. Hindi sa verbal lang yan. Doon nagkakaroon ng problema kung verbal lang. But it is very clear, the one who pays for the work and the work is made in pursuance of the commission, then the ownership of the work is the one who commissioned the work. But the authorship of the commissioned work or the copyright of that commissioned work is retained by the one who performed that work.
Okay, I think it's very clear.
Diba?
Yes.
Oo. So, mas maluwot yun, no? May pagka-complicated dyan. Kaya nga, tama ka, Tony Lawrence, no? Ilagay mabuti sa kontrata kung anong kanilang arrangement para hindi sila nagkakaroon ng dispute.
Correct. And to that point, Sam Marcelo says, one more try. Questions for Ballet Philippines. Are there any updates on the cease and desist letter that BP sent to CCP regarding Alices Reyes Itim Asu? Is Ballet Philippines thinking of taking legal action against Alice Reyes Dance Philippines if the company stages works by Alice Reyes and Agnes 16 that were produced under the auspices of Ballet Philippines? I don't think Rico
I'm
is
not
in a
privy to
position.
that, Lawrence. No. I
Yes, I
don't know
don't think
the culture.
Rico is probably not in a position to answer this. May I suggest to Sam that it be directed either to Ballet Philippines or to CCP? What's important here is the principle. No? It's the print to me. The more important here is the viewing public. Let's not deprive the public of good creations, whether it be dance, music, theater. The public is benefited from the parties not quarreling, whether it's Ballet Philippines, Alice Reyes, or CCP. I think the Constitution says intellectual property must have a social function. And to me, that social function of art is to bring happiness and not discord to people. So I would I would say here that perhaps Ballet Philippines, CCP, and Alice Reyes should finally sit down and come out with a happy solution. Okay, thank you. And
Okay, thank you so much. Thank you so much. And with that, we will close the Q&A. Thank you so much, Attorney Kapunan. Thank you so much, Attorney Rico, as
wait, I
well.
think if we have one more minute, we have two more questions. Rico, you want to read them?
Okay, all right.
Anong question natin?
From Oliver, we have one from Oliver Ligayu.
So what is
from
the,
Emil Bautista, and
medyo mahaba ito. What exactly is the crux of the question?
Oliver, can you unmute yourself and ask the question na lang? Medyo mahaba yung question.
Hello,
Oliver,
sir.
are you here? Yes, there
Hi,
you are.
Oliver. Hi, Oliver. Sige.
Hi, Oliver.
No, I'm into fintech, and we've had recently encountered. I don't know if you're familiar with this. It's called non-fungible tokens,
Yes, yes.
where works of art of our national artists are going to be proposed to be minted into NFT.
Okay.
Because otherwise these works of art are not for sale. Obviously, it's owned by the Philippines, right? But if people want to own a digital copy of that, therefore it's minted by a minting company, an NFT minting company. And as such, I wanted to know, do we have any legislation or copyright rules insofar as this process is concerned? And because it's going to be a very hefty market, no, for digital art or NFT to be traded eventually. In its current format globally, when you mint a work of art, let's say for example the value is $1 million. When it is minted, the default value is about 35% of that. And then it earns its way eventually higher than the original price when it's traded in the secondary market. And that's where Jamie was answering the question. But I wanted to know if our laws, our copyright laws, are up to date insofar as minting NFTs are concerned, and especially if the owners of the artworks are no longer around.
Jimmy, Jimmy, unfortunately, you're Jimmy, no? Jamie? Oliver. Unfortunately, that's actually a subject matter of one of the theses that I have advised on. No? Unfortunately, we do not have exactly the type of legislation that would govern NPF, no? NFT rather.
Yeah.
NFT. In other words, non-fungible. In other words, hindi pa nakaka-step up ang ating copyright law on that kind of work, such that there is no regulation directly applicable to what you're talking about right now. I would admit that wala pa tayong mabibigay na solusyon dyan ngayon. And it will be simply, as you mentioned, I think, it will be purely a consensual kind of thing. Kung magkano ang inyong pagbibili and how much are you going to put it under what medium, then you have to put that in a contractual form. We have contracts in other jurisdictions because they have laws on those items already, no, Oliver?
Okay.
But we just have probably, baka naman pwede nyo gawin muna for the moment, make it a trade secret so that it will be valuable, so that when you try to sell or license that item, it will be at least protected by some stipulations or contract. But right now, our copyright laws are not in tune or attuned to that type of contractual situation.
Okay. Thank you very much, Attorney. Yeah, thank you.
Unfortunately.
So I guess the next step here would be if we have representation in Congress to pass this, or at least improve this part of copyright laws into our legislation.
Correct. You have not stepped up to that, no? To that point.
Right. Thank you so much, sir.
I think to that point, Oliver, no, Rico and I belong to the Intellectual Property Association of the Philippines, and part of our advocacy is legislation protecting intellectual property rights, and that addresses your issue on protecting future rights like NFTs. And I think Rico is going to be the next president of our association. So be assured that there will be legislation to that effect. And perhaps we should make clearer, Rico, no, our copyright laws, because from our chat group, although it has been very informative, the issue of commissioned work and who owns the commissioned work still remains an issue. No? But let me just be clear if I understand Rico right, and if we are correct. Commissioned work belongs to whoever is commissioned.
Correct.
And if that is the employer, it belongs to the employer. If it is not commissioned work, or if the employee, even if there is an employer-employee relationship, if the employee does that work and it is not part of his scope of duties, or does it without using employer's resources and employer's time, then that is not covered by ownership by the employer or the organization that commissioned it. But at the end of the day, the creator of a work still retains rights to that work. Correct, Rico?
Correct.
As the creator, may economic rights yan, may moral rights yan. And that is why, to avoid confusion on the matter, it is best moving forward that you as artists be aware of your rights, and that you protect yourselves with clear contracts. So
in fact, Lawrence, if I may interrupt, no, just to give the creative workers more perspective exactly what they ought to be preparing for when they get into engagements, you know, in creative work industry. We can probably have a sequel lecture on this, and we will provide them with a template of the contracts that they may want to consider as part of our advocacy, Lawrence, no? As intellectual property lawyers, we would be happy to lend to you. In fact, I lend that to my classes in Ateneo Law. No? Meron akong mga master templated contracts that I would give them, because I know there'll be future lawyers. So when they are in IP practice, they would use my templates as models for such contractual obligations and arrangements. So gagawin din natin siguro yan. If with your permission, we can provide them the templated contract models. No?
That's very good. So Ballet Philippines and all of you who are listening here, itaga nyo sa bato. Ang sabi ng Attorney Rico, kung gusto nyo ng format or sample ng contract, we will make them available as part of our advocacy. Thank you also to someone who is from the
Oliver.
maritime training sector and also a licensed teacher. Mary Tolentino says this has been very informative and very helpful to her. So thank you to Ballet Philippines and the organizers of this masterclass. And of course, to our legal expert on copyright and intellectual property, Rico Domingo.
You're
So
welcome.
I just like to end by saying, at the end of the day, it is the public that is benefited from all your creative work. It is the nation, and we are the most productive in the whole universe. The Filipino race is the most productive in the entire universe. So keep on creating and love and protect your creations. Maraming salamat po for this opportunity. Thank you, Mai. Thank you, Ballet Philippines.
Okay, thank you so much. Thank you so much, Attorneys Rico and Attorneys Lorna. That will conclude our creators, copyrights, and IP masterclass. Thank you so much for your time and for sharing your expertise with us today. I think we need a part two of this because it has been so informative. We hope that this has been an enlightening and empowering experience for everyone. We also look forward to seeing more of you during the 53rd season as we prepare our much awaited return to the grand stage. Feel free to visit our website and follow us on Instagram at Ballet Philippines and join us as we dance where no one else has. Again, on behalf of the Ballet Philippines team, thank you for joining us today. Bye.
Thank you so much, Rico. Maraming
Thank
salamat.
you,
Thank
Lawrence.
you,
Thank you.
everybody.
Bye. Thank you. You're welcome.
Any commentaries made by today's esteemed speakers are not official statements from Ballet Philippines.